Hello and welcome back. I hope you've all had a chance to grab a quick cup of tea or coffee as we move into session 2 of today's event, focused around the patient perspective and the legal and compensation issues associated with a diagnosis of mesothelioma. The first persons to speak to us today is Fraser Simpson from Digby Brown. Not only are Digby Brown sponsoring today's event, but they've also very kindly allowed Fraser to speak to us as well. Fraser's head of the Specialist Occupational Disease Team, which has been providing expert support and advice to those diagnosed with an asbestos-related condition for the past 25 years. Fraser's kindly agreed to give us all some guidance around the legal aspects associated with a diagnosis of mesothelioma. Thank you so much.
Good afternoon, everybody. It's a pleasure to be here. This talk is rather grandly entitled "A Legal Guide for Clinicians," and I have 15 minutes. Anyone who knows me will know that I struggle to confine any talk on any subject matter to 15 minutes, but I will give it a go. I thought the best place to start here was really just to continue from where Laura Blaine left off on her excellent talk on the last event held, and provide some additional insight and context into our approach as specialist occupational disease litigators, and also to focus on what we can actually achieve, with particular reference on 3 areas that I think would benefit from being highlighted for the benefit of clinicians. Namely, the work that we can do in terms of recovery of non-HS treatment costs. Similarly, the work we can do to recover future needs and end-of-life care costs not otherwise provided by statutory providers. And finally, finish on a positive note by highlighting the mesothelioma exception for families, which Scot law has, much to the jealousy of many other legal jurisdictions. It will come as a huge surprise to you all, of course, to learn that personal injury lawyers don't have a particularly good reputation amongst the general public. I think we come somewhere below tabloid journalists and second-hand car salesmen, although I think we do still rate above dentists. But I think actually there's good reason for this. In the legal profession, there's a tendency for many lawyers to dabble in areas that they are not expert in. And if there's one singular message I'd like anyone to take away, is that in this specialist and often highly technical field, it is imperative that mesothelioma sufferers, asbestos victims generally, are represented by specialist solicitors. And certainly Laura and her a fantastic team at Thompson's and our specialist team at Digby Brown, I would suggest, do have the pedigree, experience, expertise, and the landmark legal cases that we can point to demonstrate our expertise. And again, I would hope that clinicians would be able to offer reassurance that any specialist firm instructed by a support group would have the necessary expertise to be able to progress this work efficiently and effectively. Our approach when building a solicitor-client relationship is very much to accentuate the positive and deal with the negative as well. We don't just develop a professional relationship with clients, but inevitably it becomes a personal relationship as well. We would like to do everything face-to-face. We never look to establish relationships by way of correspondence or by forwarding volumes of paperwork to be signed at the outset. It has to be personal. We would give certain undertakings at the outset. We do not wish to distract from other life priorities at this key stage. We would offer a continuity of representation throughout. The individual will not be passed from solicitor to solicitor. It's important to build that relationship. Speed of outcome is very important. These days, the litigation process can and is truncated for mesothelioma cases. Generally, we would look to complete investigations and litigate all mesothelioma cases of merit as quickly as possible. And once litigated, we would normally expect the courts to accelerate a timetable so that we can bring matters to a final conclusion within a period of 3 or 4 months. And rarely is that opposed by the other side in such cases. Our message really is that we are trying to help clients to keep on keeping on, to make the most and gain the greatest value from the time that they have. Another important point is preservation of evidence. I will come back to this, but it is important, where possible, that we have access to clients as early as possible before their health deteriorates, for the purpose of preserving evidence of negligent asbestos exposure. Even if the client does not wish to proceed with a civil damages claim, if we preserve that evidence, then it's there and can be relied upon should they change their mind as their health deteriorates. And in addition, the evidence is available for family members should they wish to rely upon in due course. Eliminate the positives. I apologise for the photograph. I just wanted the photograph somewhere in here, and this was really the most important, the most appropriate position. We don't mention the C word. Compensation has connotations of a windfall, of a lottery win. What we do, as Laura explained last time, could not be further from that. We look to remove the fear from the process, and certainly would not involve any risk of any legal expense. Part of our job is accomplished if at the end of the day we leave no stone unturned, we investigate matters thoroughly, we answer questions for clients, even if there is no successful reparation outcome. We've done our job properly if we've done everything that we possibly can. Laura dealt with this last time. There's a limit to what we can achieve as reparation lawyers. Reparation is underpinned by a doctrine, restitutio in integrum, a Latin phrase that really means to try to return the sufferer back into the position they were as if the wrongdoing had not occurred. That is preposterous when it comes to serious injury or disease. No one can turn the clock back, and the only tool the law has to afford a proper reparation remedy is financial damages. So that is why we ultimately have to use the language of damages. Patrimonial loss, financial loss, and non-patrimonial. And the only point I wish to make here is that the range of damages can stem from significant elements such as future financial loss based upon loss of life expectancy and loss of earnings, down to very small elements of loss, including matters such as travelling expenses to and from medical appointments, accommodation for medical appointments, sustenance, etc. Basically everything that has been incurred by way of financial expense and loss that would not otherwise have been incurred had it not been for the diagnosis, which in turn has been caused as a result of the negligence upon which every damages claim is predicated. So turning to aspects of damages that we can recover, again I would like to highlight this aspect. We can recover any reasonable loss incurred as long as it's not too remote from the original wrongdoing. In terms of treatment costs, that includes any treatment costs that may be incurred privately. We do not engage in discussions of a clinical nature with clients for obvious reasons. It's not our place. But of course, in this field, we often come across clients who have had discussions about immunotherapy treatment. Of course, we're aware that since January, early access to medicine scheme, the Ipinevo first-line treatment has been available under the NHS, but there are certainly aspects of immunotherapy and other treatments that are not covered, as we've just heard. The bar for the courts is very low in terms of a threshold as to whether we can recover these costs. There are three clinical objectives, of course, in cases such as this: to prolong life, palliate symptoms, and improve quality of life. If any of these can be confirmed, either on the basis of a possibility, not a probability, then it is likely, if the client meets the eligibility criteria for treatment from a clinical perspective, it is likely that we would be able to persuade a court that we will be able to recover damages. And we have done so successfully in several cases. However, I believe that there is a disproportionate number of cases in Scotland where we have been called upon to recover immunotherapy costs compared to our colleagues in England. I was at a conference 2 weeks ago run by the Association of Personal Injury Lawyers. It's their annual asbestos conference. And one of your colleagues from South Wales is speaking at it, Dr. Jason Lester. Now, I appreciate that Dr. Lester can sometimes be a rather controversial figure, but I was speaking to him after this and asking about what I perceived as being a difference to approach in Scotland. And he stated that he thought that was the case. He suggested, and I think this is controversial, that there may be a reticence amongst clinicians in Scotland to consider non-NHS funded treatment as a clinical option. Yeah. And that may be entirely justified. Nobody would suggest that an individual use their life savings or go into debt for the purposes of a treatment. And I appreciate there's a careful clinical balance in terms of the pros and cons of any such treatment. But I just wish to highlight that there is a potential alternative here, that it's not simply a question of a client possibly meeting the cost of such treatment from their own resources, that the principle of the polluter pays applies, that where a case has good merit, then subject to clinical approval, there is every reason to suppose that we would be able to recover costs from the wrongdoer. In fact, usually the insurer or paymaster behind a former occupation or employer. I wonder whether there needs to be improved communication in this regard between clinicians and specialist lawyers so that there's an awareness of those cases where such recovery can be made. In appropriate cases, recovery can be obtained at an early stage by way of interim settlement or within a reasonably short period in view of the truncated procedure that can be adopted in certain cases. I believe it's an avenue that would merit further discussion. On a similar vein, I wish to highlight another head of claim that we now routinely include in all of our mesothelioma cases. We now instruct in all cases specialist immediate needs assessment from a clinical specialist to look at the issue of future care needs that are not otherwise provided by statutory providers. As I'm sure we're all aware, there's a postcode lottery in Scotland. Provision of statutory services is very patchy from area to area. When we speak to clients, a desire is often expressed that an individual would like to have the dignity, have the ability to spend their latter days in their family home surrounded by their loved ones and provided appropriate care in their own private accommodation. Of course, there's a lack of awareness as to quite how much specialist care is required at the end of life stages, particularly for respiratory disease. But by employing a specialist needs assessor, we would look to quantify that to include the provision of 24 hours care where the accommodation needs afford that, where the family circumstances would justify that, in addition to any other care or immediate needs of the individual. That can be quantified. It's our job to quantify it. And again, I've never come across any successful arguments against us from a defender arguing that an individual condemned with a diagnosis of mesothelioma should not be entitled to incur the cost and to recover the cost of ensuring their dignity at the end of life stage. So again, I simply mention that just to raise awareness of our ability to look to recover these additional costs, to give clients resources and options and specialist support and advice to allow them to spend their time with the individual sufferer in the most constructive way possible, rather than to worry about the level of care which they as individuals are able to provide their family member. Finally, here on a slightly more positive note, I just wish to highlight this, which is a shining example of Scots law actually leading the way when it comes to mesothelioma. This is known as the mesothelioma exception. Generally, where an individual diagnosed with an end-of-life, a life-shortening condition can pursue a damages claim and can conclude their damages claim, but that's an end of the matter. When they pass away, there's no further remedy for family members. The exception in law in Scotland is mesothelioma, which preserves for immediate family members the right to recover damages in their own right once the mesothelioma sufferer dies, even if the mesothelioma sufferer has settled their claim in full during their lifetime. In addition, bereavement, if it can be called that, damages in Scotland are far broader than that available in England. They have a statutory damages regime in England where approximately £14,000 is recovered by the financial dependent. In Scotland, each individual immediate family member can recover damages in their own right. I hesitated to put this final slide in with figures because, as I stated before, money is not the point in large part to what we do. But I do think it's relevant for you as clinicians and as care providers to have some awareness of the benefits that immediate family members can recover in addition to the individual sufferer. And there's three reasons for this. One, it can be a comfort for the individual sufferer to know that aside from any damages they can recover, which is often irrelevant as far as they are concerned, that in due course their family will be able to recover some damages and have some financial relief for themselves. Secondly, it reinforces the importance of recovery of evidence. Even if the individual does not wish to proceed in their lifetime, if the evidence is recovered, the family would still have the option at a later date of instructing specialist solicitors to pursue a posthumous claim, which would include the rights of individual family members. And thirdly, in many cases that we're presented with, an individual may have occupational exposure with several different employers. Many may be out with the jurisdiction in England where no similar remedy for the family applies. That does not matter. Where it can be proved that an individual has an element of occupational exposure in Scotland, which can be said to have materially caused or contributed towards the mesothelioma, then proceedings can be based in Scotland against that one single employer alone, and full damages can be recovered. This is important because it allows such cross-border cases to have the benefit of the damages available in Scotland, which are significantly greater than that available in England when it comes to family members. So there we go. That's my updates for my clinical colleagues. I think at this stage I can pass you back to Caroline, and there'll be an opportunity for some questions at the end of this particular session.